Hello and welcome to Courts Today by LiveLaw. I'm Debojit Das and we bring you the day's most noteworthy legal developments every day. Today isn't any different either. From high-stakes constitutional matters in the Supreme Court to powerful pronouncements on fundamental rights from high courts, we cover everything that shapes law and policy in our country. Let's begin. The Supreme Court had their hands full with the Election Commission as they sought clarity regarding the ongoing Special Intensive Revision or SIR of electoral rolls in Bihar, acknowledging significant confusion over the final voters list. This challenge, brought by petitioners like the Association for Democratic Reforms or ADR, alleges that the SIR process, rather than cleaning the rolls, has disproportionately excluded vulnerable groups, including women and Muslims, and compounded the problems. Petitioners led by Advocate Prashant Bhushan and Senior Advocate Dr. A.M. Singhvi highlighted that after 65 lakh voters were initially deleted from the draft list, the final list announced the addition of about 21 lakh voters. But it remains unclear if these additions are names that were wrongly deleted or entirely new voters. Furthermore, an additional 3.66 lakh voters were deleted at the time the final list was published, without reasons being supplied or the list being published publicly. They argued that without the ECI publishing this data, the deleted voters cannot meaningfully file appeals, effectively denying their voting rights. The Election Commission, represented by Senior Advocate Rakesh Dwivedi, countered this, arguing that the deleted persons have been given individual orders and that the issue is being raised by politicians and NGOs sitting in Delhi rather than affected voters. However, the bench, Justices Suryakant and Joy Malia Bagchi, voiced a similar concern about the confusion over the identity of the add-ons, stating that clarity is vital to fortify confidence in the electoral process. The court ultimately directed the ECI to use the information from the draft and final lists to cull out and give us information, effectively placing the onus on the ECI to clarify the process before the next hearing. Next, we saw another momentous decision coming from the top as the Supreme Court has just escalated a critical issue affecting the morale and career trajectory of India's trial court judges, referring the matter to a constitution bench of 5 judges for a permanent solution. The core problem lies in career stagnation for those who join the judiciary at the entry level, specifically as Civil Judge Junior Division or Judicial Magistrate First Class. Currently, the system often creates an anomalous situation where these dedicated young officers who start their service early, around age 25 or 26, have severely limited promotional avenues. In many states, they may retire without ever reaching the position of a principal district judge, let alone being considered for the elevation to the High Court. This lack of upward mobility is causing what the Chief Justice of India called heartburning and is actively discouraging bright youngsters from entering the judicial service in the first place, compromising the quality of justice administration. The referral is an attempt to strike a necessary balance, potentially by implementing measures like reserving a percentage of the highest district court posts for the promotion of these entry-level judges that would ensure that years of dedicated service lead to meaningful career progression. Moving on from important issues of judicial administration to intense battle of elections, it has become obvious that the latter often relies on strong narratives, but a recent campaign video from the BJP's Assam unit has escalated to warrant the serious attention of the Supreme Court, prompting major scrutiny over the fusion of AI misuse and inflammatory political rhetoric. The heart of the controversy is an AI-generated social media video that prompted an application to the Supreme Court, alleging it broadcasts a grossly false narrative designed specifically to incite fear. The applicants detail the video's content, claiming it depicts a scenario of Muslim domination should the BJP fail to win the re-election. Specifically, allegedly alarming scenes show visibly Muslim individuals taking control of key state assets, including tea estates, the Guwahati airport, and the government lands, alongside the propagation of a false claim that 90% of the state's population constitutes of Muslims. This application forcefully argues that this act of openly targeting and demonizing a specific community fundamentally violates the constitution's secular values, asserting that the underlying message that a Muslim takeover represents the worst fate a state can be met with is a calculated tool of fear-mongering for electoral gain. Taking note of this serious claim, which touches upon the court's existing directives on taking suo motu action against hate speech, the Supreme Court has formally issued notice. This incident forces a critical reflection. Where exactly should the judicial and constitutional line be drawn between aggressive political rhetoric and the calculated exploitation of deeply rooted religious prejudices. Next, we look at a crucial public interest litigation that has been filed in the Supreme Court following tragic child deaths in Madhya Pradesh and Rajasthan linked to toxic cough syrups. Treating this as a public health emergency, the PIL targets systemic regulatory failures and demands specific action. It seeks a CBI probe into the deaths and related lapses, supervised by a former Supreme Court judge, focusing on contamination by deadly compounds like diethylene glycol and ethylene glycol found in products like Cold Riff cough syrup from Shrishan Pharma Private Limited. The plea also demands the creation of an expert committee led by a retired Supreme Court judge to conduct a comprehensive review of India's drug control mechanisms. Furthermore, it calls for the immediate recall and seizure of all implicated batches and mandates pre-distribution quality testing for all cough syrups, domestic and for export, pushing the CDSCO to significantly strengthen its oversight and monitoring of the formulations containing such dangerous solvents. We'll stay with the apex court for this decision too. Think of this ruling as the Supreme Court drawing a huge red line in the sand against economic protectionism in government tenders. The case challenged a tender condition imposed by the Chhattisgarh government for the supply of sports kits, which required bidders to have prior experience supplying goods specifically to state government agencies within Chhattisgarh. The problem, as argued before the court, was that this condition created an unreasonable and artificial barrier. A company that had successfully executed massive supply contracts for the central government or other large states was automatically deemed ineligible just because they had not worked in Chhattisgarh previously. The Supreme Court found that confining eligibility to a single state was not only irrational but is also disproportionate to the actual goal of efficiently supplying sports kits. Crucially, the court held that this restriction was arbitrary, discriminatory, and a violation of the constitutional guarantees of the doctrine of level playing field. The doctrine is rooted in Article 19(1)(g), which protects the fundamental right to practice any profession, trade, or business, and Article 14, equality before the law. The court's core message is clear. The state cannot use tender conditions to close the market to outsiders without a just cause, thereby ensuring that competition remains open and fair across the country. Next, in what has been a tragedy compounding over time, the terrifying ordeal of the Unnao rape survivors' family continues, prompting a fresh plea in the Supreme Court for their physical safety. The survivor's mother has moved the apex court, desperately seeking the restoration of their CRPF security cover, which the court recently allowed the union government to withdraw from all family members except the survivor herself. The plea alleges an immediate and grave threat to their lives, claiming that shortly after the security was pulled, their residence was attacked and ransacked with valuables stolen. This, they argue, proves the continued significant influence of the convicted BJP MLA Kuldeep Singh Sengar. This follows the tragic 2019 incident where a truck rammed the survivor's car, killing her aunts and prompting the SC to order mandatory protection. Now, responding to the urgency of the new allegations, the Supreme Court has directed the government of NCT of Delhi to file an affidavit within 2 weeks, specifically detailing whether a current threat perception exists for the family, putting the burden of proof back on the state to safeguard the victim and her relatives. Moving on to the Karnataka State Bar Council, that has taken a strict stance against increasingly prevalent use of social media by legal professionals, issuing show cause notices to at least 8 advocates. The central issue is the advocates' failure to comply with the previous August 15th resolution, directing them to remove specific videos, reels, and promotional content from their social media by August 31st. According to the Bar Council, this content constitutes unsolicited legal advice aimed explicitly at soliciting work, which they argue goes against the nobility of the profession. The notices sent via WhatsApp call on the advocates to explain within 15 days why disciplinary proceedings under Section 35 of the Advocates Act of 1961 should not be initiated against them, an action that could potentially lead to suspension or even removal from the state role of advocates. The council is firm, stating that advertising or soliciting work, whether directly or indirectly through social media platforms, is explicitly prohibited by the Bar Council of India rules, citing similar strong directives from the Madras and Delhi High Courts. From Karnataka to Rajasthan, as this recent ruling from the Rajasthan High Court is a powerful condemnation of the state's sheer indifference towards a critically ill employee. The case involved a commercial taxes officer who has been in coma since 2023 after suffering a brain hemorrhage. His wife filed a petition because the government had been denying his salary for over a year and refused to reimburse his staggering medical bills without any justified reason. Justice Ravi Charania expressed profound pain at this inhumane and arbitrary approach, observing that the state had effectively declared the employee who worked for them with honesty and dedication as deadwood the moment he became ill. The court was clear that the state's actions constituted a serious violation of Article 21 of the Constitution of India, which guarantees every person the fundamental right to a dignified life and health. Furthermore, the court highlighted that this neglect violated the Persons with Disabilities Act of 2016, specifically Section 20, subsection 4, which prohibits reducing the rank or dispensing with the services of an employee who acquires a disability during service. Considering the overwhelming financial burden of a person in a coma, the court cut through administrative delays, ordering the state to immediately examine and pay all due salary and pending medical bills within 7 days, demanding that all future medical bills also be paid without administrative hurdles. That's all from our side on courts today. Whether dealing with matters of national security, social media accountability, or constitutional rights, the judiciary remains at the center of the nation's most important conversations. For detailed reporting and analysis on all the cases we cover here, visit www.livelaw.in and follow us on Instagram and YouTube to stay updated with everything that is law.